someone who takes our then sound. What about Africa? Too much Africa. What much Africa? What much Africa? Oh, oh. Togi capins. Follow the capins. Togi capins. As the one, very much there. Mike, another Mike. Number one, but to see Togi, the Togi capins. No, where nothing is. Yeah, thank you. Thank you. We are going to do what is called Sasko has talent, and it's the first contestant. And to see what will get a escape room. We are sharing about ready. This side, nobody. And to put the piece of green or green, and it's rosa, 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 six rosa. One of me, one. Bashayeli Santa, Bashayeli Santa. Rosa, rosa, sisi, rosa, rosa.
Good evening. A very, very warm welcome to everyone. I see some of our guests are still joining us. So, my name is Sumiri Yun. I'm the head of Department of Private Law here at the Faculty of Law. And from my side, a very, very warm welcome to everyone. I see some of our students, some of the faculty staff, family, friends, and of course, colleagues from other institutions. You are all very, very welcome. So, this is a very joyous occasion for us, the inaugural lecture of Professor Anthony Diala. And we are very glad that you are here to celebrate this evening with us. So, some of our colleagues are still putting on their gowns, and when the deputy registrar gives me the signal, I will ask you all to please stand up to let the procession just come in. And while we are still standing, we will sing the national anthem. After that, our DVC academic will introduce Professor Anthony Diala. He will then have his inaugural lecture. There will be a respondent, and then Professor Liam Wambeni will do the vote of thanks. Afterwards, you are very welcome to join us for refreshments and photographs in the foyer upstairs. All right. I think I've got 1 more minute before we are supposed to be standing. Are there any questions? Not for me. All right. Just to also just notify you, the restroom, there's a restroom upstairs at the back. There are also restrooms downstairs. All right. You are welcome to stand. Thank you very much. Thank you very much. You are welcome to be seated. A very warm welcome also to our faculty, to our executive, and a very warm welcome to Professor Anthony Diala. It's a real honor to welcome Professor Diala here this evening and celebrate wonderful work that he's achieved over many years. We are extremely proud of him and what he's done over the last couple of years. So a warm welcome also to our DVC academic, Professor Halahala, the Executive Dean, Professor De Vol, then also some of our other colleagues from other faculties, management, executive, you are very, very welcome. I'm now going to ask Professor Halahala to just introduce Professor Diala and open for us. Thank you, Prof.
I'm not sure, Chair, whether it's evening or early evening or still late afternoon. Perhaps you can guide me. Late afternoon. Let's say early evening. Thank you very much. Ladies and gentlemen, friends, colleagues, esteemed guests, good evening. I'm sure you can do better than that. Good evening. Thank you very much. Thank you very much. I carry warm greetings from the Office of the Vice Chancellor, Professor Robert Balfour, who could not join us this evening because of other engagements. But Prof. Balfour, to you, Prof. Diala, he has asked me to offer his best wishes for a successful inaugural lecture this evening. So please record that. Because otherwise, if it doesn't get through, I will be in trouble. Colleagues, I also wish to offer my thanks and my special welcome to everybody, especially Prof. Diala and the family. If I can just see some hands, if they are here with us. And this is a special welcome to you because he is what he is today because of your support. I want to emphasize that. Of course, I would also like to take the opportunity to acknowledge all of you on behalf of the University of the Western Cape. We extend a very warm welcome to everybody, and we want to thank you for being here this evening, for gracing this important occasion in honor of Prof. Diala with your presence. Chair, it will be remiss of me not to acknowledge the leadership of the faculty, the Dean, Prof. DeVille, and of course, Prof. Leah and Prof. Mesmer sitting side by side. And we say thank you for supporting this event and possibly many, many more. With your guidance and your leadership, this is important. And of course, top of my list is the colleagues who always work behind the scenes to see to it that an event like this is a great success. I mean, our AVS, some colleagues in the faculty, I believe this has been a collective effort. Now that we hear this evening, we see it is now happening. And I wish to acknowledge our further inquiry. Whether we can foretell one of our very important university to accept that you are history, becoming important, collectively, that it to respond and check in appreciation as the university community. The presentation of my lecture is a tradition to the see that we within the tradition I just used. Of course, the presentation of my lecture as we say, the bishop lives with the control of the state of court of the city to someone who has gone through the sick, the tower of the and it is a moment in which the accused meets family where they investigate. So of course, students who are doing that very critically respond and certainly the intellectual relationship is so wide justice. And if we want this evening is a celebration for Australia, which is laughter, which is a laughter that is on the religion in honor of unity. So it's called something. So you demand of the one is about. We don't want to know this when your teacher tells the good teacher explains, the superior teacher demonstrates, and of course the great teacher inspires. And I want to believe that we are being celebrated this evening because of the inspiration, not only to your peers, colleagues, but more importantly to the students. So, colleagues, without further ado, as the Deputy Vice Chancellor to the University of Washington, I hereby declare the simple lecture titled the foundation values of religion, those with a framework for academic knowledge to be presented on President Diala of the very University.
Thank you very much, Professor Halakala. I think you could all join me in putting your hands together for Professor Diala as he comes and gives his inaugural lecture. Yeah.
I apologize, the program has seen a little bit of a last minute change. And so I just want to quickly introduce Professor Diala before he comes up. So thank you very much to all of you for joining us here tonight. So just a few words, Professor Diala has a very long and impressive CV. I'm just going to highlight a few things of relevance. So Professor Diala joined us in 2018 at UWC as a senior lecturer, and they very quickly went up the ranks, and he became full professor from 1 January 2024 in the Department of Private Law, and as you all know, he's in the field of legal pluralism. He's also our director of the Center for Legal Integration in Africa since 2021, and the center was established under his leadership in 2020. He holds a PhD from the University of Cape Town, which he obtained in 2016, and also a Master of Laws in Human Rights and Democratization from the University of Pretoria, which he obtained in 2007. He holds an NRF rating of C2, and he has also successfully supervised already 4 PhDs and 17 master students. He's the author of 42 publications, and that includes 3 books, of which he is either the author or the editor. He's also the editor of various journals, and he's the member of various boards and councils, etc. He has networks all over the world. He travels frequently, and he has teaching and supervision experience in Germany, Italy, South Africa, and Nigeria. So Professor Diala is a scholar of repute, and I invite him to come to the stage. Professor Diala. You know, I look forward to this moment in the past 15 years since
And now at the moment has come. It's a mixed bag of emotions. What can I say? Let me thank all of you for coming. The opening protocols have been done, so I'm going to jump straight to it. Unfortunately, you've seen a few pictures you were not supposed to see, but you're going to see this picture again, and I'm going to explain it for you. So welcome and good evening once again. But I will start with how I got here, my journey to becoming a professor of law. I was born near the end of the 1970s in a part of Nigeria that is often subject of political marginalization. If you heard of Biafra, Biafra fought a civil war with Nigeria and lost. Generally, the Nigerians here, we are very much aware that if you in Nigeria, you are born in Nigeria, automatically life is moving you 1-0. That's a football balance. If you are from my part of the country, life is leading you 2-0 without any kickoff done. The match hasn't started yet. Then if your parents are poor, it's 3-0 down. My parents were not poor in the sense of being poor. My father actually qualifies as middle class, but he lost his job. And then he ended up in the village. So those formative years in the village, that's where I grew up. They shaped who I am today and my interest in African customer law. So some of the things I'll be telling you today, I experienced firsthand growing up in the village. Right? I attended Enugu State University of Science and Technology. I was admitted to study accountancy. I'll tell you why. I'll show you why that happened with the picture. I switched after a year, then I went to the Nigerian Law School and eventually served my country in the National Youth Service Corps and commenced my work career in 2004. I started as a legal aid attorney in the Justice and Peace Commission. So I was defending people for free. I was doing some of the best work. But at some point, I felt that I wasn't doing enough. So what did I do? I decided that I would not return to school to empower myself. That's how I ended up into prayer. So before then, let me show you some pictures. You may have seen some of those pictures when they were flashed on the screen accidentally. Now, some of the pictures that you show, they are quite fun. You are permitted to laugh. That's the thing. But if you laugh too hard, you will be escorted. That picture is still ready. That man there is the one that forced me to study accountancy. When I had spent 1 year in the university, I became bold enough to tell him that, look, it's either law or nothing. So you see me there at 2 years and there at university. I have always been, because when I was searching for pictures, I didn't know how hard it is to find pictures from your childhood and early years. But I discovered that actually I've always been in leadership. That's me, if I taking the oath of office as a senior advocate in the university. And then later as a registrar of the Judicial Council. At UCT, there I led the Postgraduate Law Student Council. You see me right there on top. And then the other picture when I passed out from the National Youth Service Corps in Nigeria. Then I ended up at the International Criminal Court. So my journey has been from that NGO in Nigeria to the University of Victoria. You see me being roped for my LLM there in 2007. And then I straight from there went to the International Criminal Tribunal from Rwanda, where I did an internship for 6 months. And immediately afterwards, I went to the International Criminal Court for another internship. And when I finished from there, I worked briefly at the International Criminal Court. Now, that's where my career switched. I was, shall I say, disappointed or rather depressed by some of the work I did at ISIS. I was young and idealistic. I had left law school with high hopes of changing the world. My lecturers had pumped me full of passion. So I came out thinking I could change the world. But I left that NGO that I was working as a legal editor because I felt I was not making enough difference. Thought I should empower myself, then come back to the higher position. But the ICT, I dealt with evidence in the court case. Those of you who are familiar with Umar Sudan, I handled graphic evidence, too graphic to describe, and I couldn't handle it. I decided that the best way I can make a difference in society is to raise a new generation of scholars who will change agents in society and make things better experiences for others. That's how I became an academic. So I ended up in Madonna University and started teaching there in 2010. That was the moment I started looking for to this day. Eventually, I went to the University of Cape Town for my doctorate, and that picture right there at the end is me at the World Academy in Ireland. That's my first international presentation as a student in 2015. I put it there because it was a milestone for me, the beginning of my dreams and the journey where I am currently. So there, Madonna University, UCT, and finally to UWC in 2018. Right, now you'll be able to understand what I profess. Right? So what do I profess? I profess African legal pluralism. But that's a heavy phrase. It's a heavy phrase that I need to break down. So here we go. Look at those countries listed there. These are European countries that colonized Africa. You have to do some sort of naming and shaming because it's not part of Europe that is guilty of colonialism. So I listed them there so you can see for yourself. Now, what do they do here? Basically, they impose their culture on Africans. We call it colonialism today, but it has quite a significant impact on the laws that apply in the continent. So the most important thing is that colonialism entrenched a Western way of being, Western way of knowledge, Western way of understanding the world, a European way, basically Euro-American. So this affects the ways Africans behave because the laws that were imposed by the Europeans coexist and they interact and they manipulate and they dominate and they control the indigenous African law. And it's a problem, it's our opinion. So we have legal pluralism, the coexistence of different legal systems in Africa, but it's legal pluralism of a problematic kind because of what we call conflict of laws. So basically what happened is this, that this imposition of laws did not happen in isolation. There were numerous radical changes in the lives of Africans, from new ways of education to new religious beliefs, fashion, food, technology. Every aspect of life here was affected by European colonialism. So what they imposed European laws that later became statutory laws, what they do in essence, in a summary form, is that they mold Africans into the normative image of Europeans so that they behave like Europeans. So they are Europeans in black African skin. That's the nature of laws. Continue. Now, it's problematic for two reasons. First one is that indigenous African laws emerge in agricultural settings. And in these agrarian settings, laws and values aim at the welfare of the group, not an individual. So you have to take care of the entire family, you have to make sure that everybody was careful. In this type of setting, the rule of male primogeniture was best suited for social organization. What is this rule of male primogeniture? The rule is that the eldest male member of the family would inherit property, but not for himself. He inherited on behalf of do and things, and he used the property to take care of the one. So this is the kind of social system in which indigenous African laws made. But importantly, income was produced as a group. So unlike now, we have doctors, lawyers, people earning income individually. Income was produced as a group, and this also affected rights and obligations. So this was a type of society in which the Europeans imposed their laws. Now, what type of laws were imposed by the Europeans? I'll tell you, they were industrial laws. In other words, Europe had just entered the second industrial revolution. So they were bringing laws that were individualistic in nature, laws that were capitalist, profit-oriented, and laws that were rigid, difficult to fix, to change. So precedents All these they brought and imposed them over indigenous African. In this type of situation, what could possibly go wrong? The end result is that indigenous laws are heavily regulated by these imposed laws that eventually became statutory laws. And the regulation revolves around what constitutes proper behavior or acceptable conduct. Remember that colonialism claimed to be a civilizing nation. In other words, Africans were considered barbarian, uncivilized, and so they needed to become what? To become civilized. That mentality still obtains till the present moment. When we use our constitutional bills of rights to regulate indigenous African laws, we are carrying over that mentality that these laws are not good enough. They must conform to European ideas of proper behavior. So there we go. I started my critique. So it's not enough to go on about the nature of African laws. This was the very first influential article that I wrote, wherein I set out the framework for a comprehensive African legal theory. So this, in 2017, I had graduated just the year before, and with this article, I announced myself to the world. I followed it up. You can see the titles of my article that they are quite critical. Huh? Look at that one. The butterfly that tells itself there. Wherein I critiqued the identity of customary courts in Nigeria, and I identified from these two articles 3 types of legal orders in Africa. And this identification was done with the aid of field work that I conducted in Somaliland, in Nigeria, and here in South Africa. South Africa as recently as 2022 to 2024. Right. I told you that statutory laws are basically European laws and their adaptations. So survivors of these imposed colonial laws and their various adaptations constitute statutory laws, and they regulate the rest. They came from legal transplants. Here in South Africa, we call them either the English common law and the Roman Dutch law. Then the second category, indigenous African laws. They are pre-colonial norms, which, like as I explained to you, emerged with the purpose of what? Promoting group welfare. And they are still observed in their ancient forms. And then finally, we have the third category, and that's African customary law. It's a hybrid, a mixture of these two, a mixture of colonial influences and indigenous African law. So these are the 3 types of legal orders. And for there to be legal integration, for there to emerge an African common law in African countries, South African common law, Nigerian common law, Kenyan common law, and certain things need to happen. And the first thing that needs to happen is for us to do what? To understand what the problem is. I always ask people, what's the problem with African customary law? Why do you turn down your nose on that normative system? The problem is very simple. It started all the way from the colonial period, when customs were regulated with a judicial criterion known as the recognized cases. As I've been trying to explain to you, it simply means that look, for a custom to be accepted as a normal, is valid as legitimate. It has to satisfy certain criteria that are foreign, that are not indigenous. So you can see them right there: public policy, natural justice, equity, and good conscience. Whatever these things mean. There was a Nigerian judge who at some point expressed some helplessness and confusion to the meaning of this recognized case. So what is natural justice? What is equity? What is good conscience? The colonial judges interpreted these phrases any way they felt now. They woke up that morning. You wouldn't have to know. So eventually, what happened after independence? When African countries gained political independence, do you think that they then started afresh? They changed the entrenched colonial systems? Far from it, they continued. They merely rechristened them, gave them a different name. So now we are using constitutional bills of rights to regulate indigenous African laws, and the philosophy of regulation remains the same as what it was in the past. And that is that indigenous laws are inferior and that they need to be civilized. I call this Juris Party organization. Juris Party being when judges interpret laws in a way that destroys these laws. We've got so many decisions in South Africa. The most popular is the case of ascertained. So the rule of measurement nature was struck down in the courts with arguably little sensitivity to the values that accompany this law. So I'm saying that this type of judicial approach is dangerous because legal history tells us that if you continue destroying your own indigenous laws, eventually they will completely disappear. And when a common law emerges in your country, there will be very little indigenous input in it, and it will mostly be made up of a colonially imposed laws. That's what we learned from the history of Roman conquest of Britain, from the history of British conquest of the United States, Canada, and other parts of the world. So I'm warning the future of laws in Africa is in peril. You can see what I put up there. Our laws are better than yours. Another provocative title, trying to show what will happen to indigenous African laws if policymakers do not take deliberate action to preserve the values of these laws. Then I went more direct by explaining what is happening and presenting a theory that I call adaptive legal pluralism. I shall come to that in a moment. So that's my own contribution to legal theory in Africa. I call it adaptive legal pluralism. Then I went further than that by presenting a new way of approaching legal pluralism in Africa through that book that you see there, Reimagining Legal Pluralism. Right. So then, that brings us to a crucial concept. It is not enough to present a theory, but how do you prosecute that theory? How do you bring it to life? And I present to you the foundational values of indigenous African law. Now, what are these values? What they mean? In a general sense, values denote what is right or wrong behavior. Very simple. What is right behavior? What is wrong behavior? What is acceptable? What is majoritarian practice? What is minority practice? All these can be traced from values. But values go beyond that. There is a sense in which values explain the nature of law. In a real sense of law, comprises two elements. The first one is social behavior, the action that you take. But it also must be accompanied by a sense of obligation for it to constitute law. Let me give a very simple example that can resonate with most of us. So you prefer to go to Checkers for your shopping. You don't go to Pick and Pay, you don't go to ShopRite. Why? The mere action of going to ShopRite without going to the other ones, that's social behavior. But if there's a sense of obligation, if you are afraid of some consequences that will happen if you do not go to a particular shop over the other, then that's when law is formed. And it is values that help us to arrive at when this happens. Now, the foundational values of indigenous African laws perform a very crucial role. They help us to understand the agrarian social settings in which African laws emerge. Once you are able to understand these settings, then you will be able to understand how these values are compelling people to adjust their behavior to the radical socio-economic changes that colonialism introduced into the lives of Africans. I don't want to jump ahead, but I always say that colonialism is misunderstood. The real danger actually is globalization. Colonialism is like the shock troops of globalization, like the commandos, those that go in and seize the field and prepare the ground for the main infantry to roll in. That's how it is with globalization approach. So colonialism is the vanguard of globalization, and the danger posed to indigenous African laws today comes mainly from globalization, not colonialism. Right. Now, the social settings of indigenous African laws are marked by communality. They are marked by what? Spirituality, by needs of defense. Remember, in those days, no fancy technology. People live in, how many of you have been to villages before? Those areas, I should have put up some slides here in my village to show you. what it was before modernity came in. So people lived separated by thick forests. They had to defend themselves from wild animals, from slave raiders, from leaders. So they lived in close-knit units. Everyone knew everyone else. So it was easy for rights and obligations to be group-based and for the welfare of every family member. That's the kind of social settings Africans live in. These indigenous values, these foundational values help us to understand these social settings and why we struggle. So the first foundational value, some might disagree that there are values that should not belong here, or that there are others that should have been included here. Note one thing about African laws. We have staggering cultural diversity on the continent. So customs might differ from even within a community. So what I present as foundational values of indigenous African laws, even though they are like empirical work, but they are more like general principles. They are not specific. They can be applied across African communities. And the first one on the list is Ubuntu. Everyone knows this one. Doesn't mean it's like, okay? But it gives you an idea of how the people of ancient times perceived the world in an integrated, holistic way, reconciling the past with the present and the future. That's how they saw. So I am because you are, or through you. So everyone had to take care of everyone else. Ubuntu was the constitution of pre-colonial societies. The same way we have the constitution in South Africa, 1996 constitution. Same way we have constitutions in African countries. That's how it served as the constitution of pre-colonial societies. The second foundational value that is very important is one that I call the best interest of the family. Now, what does this mean? Remember the social settings I explained to you earlier on. Mere primogeniture, one person inheriting property, not for his own alone, but for the benefit of the entire family. And in those types of societies, the eldest male member of the family was usually the family head. There were reasons for this. Some communities assumed that because he was the eldest, therefore he would be the wisest. Sometimes he would be the strongest. So he performed three roles: spiritual role, transiting between the ancestors, the material world on earth with the spiritual world of ancestors. He performed a military role, organizing the young men, the warriors, to defend the community, defend the family. And then he also performed economic roles or political roles by doing what? Organizing work parties. People farmed in groups, hunted in groups, and then he made sure that everyone was taken care of. It was a system of care that was disrupted by colonialism. And for us to deal with conflict of laws today, we must understand these social settings from which the laws emerge and the values that inform them. Right. I have explained how these welfarist social settings met the best interest of the clan, functional value of succession. But does it stop there? It does not. There is a value known as preservation of the ancestral home. Now, the ancestral home is a very important site. It's the equivalent of the modern church or the mosque because land was sacred in pre-colonial societies. People worship on land. The eldest male member of the family head, poured libations to the ancestors on land. So land was considered very sacred, and it was important to preserve the ancestral home because it served as the shrine, a place of communication with the other world. Now, you know what some communities do? They would entrust the family home to the eldest male member of the family, believing that he would live the longest or that he is the wisest and strongest to protect it. In some communities, like in Botswana, they will give it to the youngest male child, believing that he would live the longest to protect the ancestral home. But the most important thing is that the ancestral home must be preserved because it's a foundational value. Now, there's another one, family involvement in marriage. My students are familiar with this story. I'll try to summarize the story. A young man went and asked his father for a bride. The question is, why would he ask his father for a bride? Why couldn't he find a bride for himself? The answer is simple because those communities, like I said, were separated by thick forests. They had little contact with other communities. They would only meet people from other communities when they went to farm or they went to the village stream. If they shared a stream, then they would meet it. So no contact with others means that they have to travel a long distance to find a bride. Just so you understand why African parents today would insist on interfering in spousal choices and they will say tradition without understanding where the tradition came from. And so the young man would speak to his father would speak to his brothers. Remember, my primogeniture. And then they will say, okay, this is not the one for him. They will from warriors. They will send warriors to a community they have friendly relations. They go there, ask the usual questions, to show a good character, and the productive, blah, blah, blah. When they finish, then the negotiations will start. Now, here's the important thing. The bride wealth, the lobola, the thing that was provided to solidify the marriage, to establish a contract between the two families, it was produced by the entire family. That wealth, the cattle, the sheep, everything was produced by the entire family. The cow, not by an individual. And why? Because there was good production of wealth, good income. And so the family was heavily involved in spousal choice, in marriage negotiation, and in the stability of the marriage. Just so you understand today the role that parents try to play in indigenous communities. So that's the best interest of the family involvement, preservation of ancestral home, and culture. We have fair trade and a few others. Well, fair trade, fairness, very simple. If you are engaging in trade by barter, you exchange goods, no cash, no currencies in those days. People exchange goods. So you have things, you have some to exchange, you have cattle, you have gold to exchange, and everybody, how can you cheat people? It was difficult to cheat people. And then everyone knew everyone else. If you cheat someone, they'll come to your house. Not today, you order something online, tell you what you ordered versus what you read. So it was different in those days. So fairness was a foundational value to indigenous Africans. I don't know if it is still surviving now, but there you go. Now there are other values like collection of the spirit of a deceased person, and that one is going now. It's now done, performed mostly symbolically. So for instance, if someone dies in a hospital, the hospital authorities will say, no, 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 can't come in here with your smoke and stomach. Go to the gates. Go perform your rituals at the gate, collect the spirit and go. So most of the content that we used to have in the past, they are now being performed in a very symbolic manner. Then we also have cross-communal rights, like primogeniture, and the inalienability of land. So remember, as I said, these values differ from community to community. Here we are with my adaptive legal pluralism. Now, I want to explain something. And before I explain it, listen to this. It's familiar. I'm sure you've heard it when I was going to. We had the traditional thing. Okay. Well, we're coming in here. Now, look at that picture on the left. See the picture on the left? This is from the Zululand University Fund. And they were playing the graduation anthem for graduation ceremony. Now, for those of you who may not know, this anthem came from Europe. Okay? I think the English equivalent is so let us withdraw. We use it here in Africa, and now we have indigenized it. Look at the colorful uniforms. These are people there wearing traditional attires, carrying South African flags, and singing a European song. Now, here is the lesson that because of the radical nature, because of the irreversible nature of the socio-economic changes imposed by colonialism, Africans have altered their lives, altered their normative behaviors in an irreversible manner. And so what does this mean for African laws? It means that we must perceive the interaction of African laws from an adaptive perspective. And I call it adaptive legal pluralism. I was inspired by the work of a sociologist, Donald Knapp, who argued that law varies in line with aspects of social life, such as status, culture, and folk. I claim that behavioral law is adaptive law. And the reason I say this is that legal orders in Africa coexist under the very strong influence of globalization, very strong influence. And that this influence compels Africans to adapt their behavior to socio-economic changes. And when they do so, their indigenous laws change and transform to African customary laws. Remember the three categories of laws are line. Fourth category, African customary laws, is a hybrid statutory influences or colonial or global influences. And the second category is indigenous African laws responding to these influences to create African customary law. So I claim that the interaction of normative orders in Africa is imitative, heavily tilted from statutory law, but that also it reflects what I call persistent patterns of power and philosophy left behind by colonialism. We call this coloniality. So because colonialism left entrenched social structures, irreversible social structures, any serious African legal theory must recognize the power of coloniality and must factor it in law reforms to produce African common law. So I present to you 5 steps to legal integration, 5 steps for the emergence of African common laws. And step number 1 is to recognize what happened to Africans. Did you know that colonialism is like war? And Africans are people who lost a war, they lost a lot. So they are conquered people dealing with the consequences. So we must recognize the influence of globalization on the behavior of Africans. And here I'm talking to judges and I'm speaking to legislators. The second step is to ascertain these foundational values of indigenous law, especially their effects on behavior. And importantly, the conversation that is taking place between statutory law and the indigenous African law. Then the third step is to substitute constitutional bills of rights with these foundational values. Now, when we say constitutional bills of rights, we usually make 3. There are 3 main culprits. 1, equality. 2, human dignity. And 3, non-discrimination. So instead of using them to strike down and destroy indigenous norms, how about we use the conventional values instead? Step number 1 is then to try to align indigenous norms with modernity. There are some norms that are no longer accepted, like patriarchy, make modernity. We've outgrown that now. The societies of ancient times, they were well suited to make modernity to patriarchy. But now we have new societies. For instance, suppose a woman who is married to a man, they will be married for 30 years, and the woman has independent income, and they managed to build 3 houses, buy some cars, etc. But because customary law does not recognize matrimonial property for women in many African countries, I'm not speaking of South Africa, in many African countries, then you say, okay, the woman will go away empty-handed after divorce, simply because customary law does not recognize the equality. That will cause problems, of course. So we must recognize that the social mechanisms are born and that the laws must adjust in line with these changes. And then finally, we can then merge customary laws with statutory laws, using these foundational values as the framework for legal integration. So do I just say these things and do nothing about it? No. We set up this center. I like to think that I set up that center and my own Fabi, my colleagues played a huge role. In fact, I remember my interview in 2018, I think it was in June. I was completing a fellowship in Nordic African Institute in Sweden when I got the call to come and interview at UWC. I cut short my fellowship by a week. I changed my flight and I flew down to South. In fact, is there anyone from HR here? I haven't gotten any reply. It's too late to apply. So during my interview, one thing that struck me was when asking my plans for the future. The dean sitting right here asked me, where do you see yourself in 5 years? I made some promises, but I'll be frank with you. So those promises were just to get a job. Yes. And set up the center would do this, that was flowing. That was going on. I had barely settled 2 months, 3 months into the job. He came to me and said, Anthony, remember that promise you made? So, yeah, he is very instrumental in setting up the Center for Media Litigation in Africa. But we try to research the environment of laws. We've conducted field work in Limpopo. You can see some of the pictures here. Limpopo province, Eastern Cape province, and we're constantly looking for funds to do more. So the hope is that we shall direct policy making on the continent toward the emergence of African common laws. Right. Let's go ahead. First, should and understand more gratitude. See, to get here has been difficult. My family is actually and all that time. Going moving to a different country or something. But I just want to be just very simply thank you for listening, taking a chance on me, and for trusting me to deliver the promises that I make. I do not take it for granted. Thank you to my colleagues, sorry, my acquaintances and friends. You can see some of the pictures right there. From UCT, from all over the world, my supervisor on the left, my colleagues from UCT, my friends. Thank you very much. People from the Nigerian Institute of Advanced Media Studies, Nigeria. And thank you to my colleagues, both from the private law department, from the wider faculty themselves. Thank you for your support and helping me to get here. Thank you to my students. My students. Very grateful for to you, including the ones that annoy me. I'm forgiving you. In all of you. Whether you have to read or not. Thank you for shaping my thoughts and for leading me to what I know. Thank you to my extended family. To my sister who have been here because of visa excellence. But I know they are watching live. Thank you, and thank you again. Then, to my nuclear family, they are here. What can I say? My kids are here. I apologize for all those mornings you woke up from sleep. They could not find me. I was gone. Some feel bad job getting me. So I don't move from me. My wife is saying, she is here at University. Says she has given a strong thought to support. A very, very strong thought of support. When I lost my mom in 1998, it was a very difficult moment for me. And it's the thing, we realize the importance of therapy. There are some unhealed trauma that if you don't have it, it affects you for the rest of your life. But what can I do? I have just simply said that you need to do. Let me just put it that way. And she's very special to me. Those of you who know me very well, know I'm very demanding person, very professional. Don't think there are very few people who can live with me. Joe thinks he's so Joe, the biblical Joe, they are not making money. She tells me that look, you behave like a machine. We will make you human. She will humanize you. Thank you, my love, for the support. Just one last thing, one last thing. Make sure you remember, it's all that money.
Um, so inspiring, the work is inspiring, and I know school evaluations are so positive. Without any doubt, you really have a gift. You experience very complex things in a very simple manner with great examples. So I'm going to give a chance to our respondent, Professor Elena. Well, thank you. I took all the calls and was always down teaching for back in the year. To respond to the lecture, I met Anthony in 2007. He was the master's student at University of Cape. I was in the fellowship at sci and we were kind of not providing enough support for some of our younger colleagues. And so I asked the person to organize a meeting with some of them who were doing the master's degree and became in them. And we began a relationship several since then. So again, it is with pleasure. I'm writing this down so that I can discipline myself. If I started to speak, I'm sure at the end of the night, of building another younger lecture. So I think this small. And speaking about the importance of what he is doing, I do not address any of the points he's made. He's entering into an area that will be heavily disputed with all kinds of reactions because it's at the fabric of what is African. So, as I said, I signal as a senior colleague responding to an Inaugural lecture. Yes. He's an accomplished scholar who has done much and for whom much is expected. He has portraits growing steadily in academic sector and public intellectual standings, producing an exceptional body of work, advising governments and their institutions, contributing to national and international debates, providing academic citizenship, services, and nurturing what is arguably the flagship of legal education studies in Africa. He has not spoken or lied, and virtually either institutes like this across Africa, I'm not aware of them. So his work in establishing that UWC in assisting him to establish that is a landmark. And in a exactly disappearing legal world of African indigenous law or Somali law. In a continent where paradoxically the norms of the majority are treated with disdain, discontent, doubt, and disrespect. Professor Diala solved an area of considerable importance in this exceptional university of struggle, resistance, and promise is to be celebrated. We honor him today with our presence and recognize that in the legal academic environment, the African universities pay lip service with the teaching, learning, and research of part of what makes us African, which is fast disappearing, and almost a footnote in the community of legal orders. It is the level of law I consider to engage with the fundamental challenge of Africa's rural legal systems, which are the foundational values of indigenous law as the framework of African common laws. And the question of which are reference and which he has that as scholarship continually. How does a normative order like the Peninsula seek to become the foundation of Africa's rural legal systems? It is part of what he has described. Put in another way, the issue is how African indigenous laws can move to the center of national legal order and become the center
what is common law implications in the process of legal integration. Integration is a technical construct of plural legal orders and is as old as the world or African nations. Professor Diala is congratulated for highlighting this important issue still neglected in several African states, where post-independence nostalgia often leads to calls for the introduction of indigenous legal orders, the dismantling of foreign legal orders, and extreme Catholic integration. But across many African countries, slowly and gradually after post-independence nostalgia, the usually awareness of and African states return to the familiar, which are taught in law schools, applied by judiciary and reforms legislation. And the commencement of South Africa's transition to a constitutional democracy, question of legal integration is in Africa, in South Africa, was a matter of procedural interest. As you mentioned, Ubuntu, many of us here know that seminar judgment in which Ubuntu was applied was actually just after South Africa had come had ended apartheid. So across the continent, South Africa's journey was received with powerful excitement when the constitutional recognition of the equality of indigenous legal orders as part of the South African common law was exceedingly celebrated as a worthy precedent. As we say that the recognition of Ubuntu as a foundational value in the constitutional law left many of us very hopeful of a genuine and transformative process towards a legal system when it not place. Some road is not the main road. But like all other African states, it is difficult not to conclude that the lack of legal integration in South Africa has been. And part of the challenge can be traced to some of how African indigenous laws and customary laws have been conceived in South Africa and in the United States. That conception is that customary law is only relevant in family personal laws, in the areas of arbitration and tenure, marriage, divorce, succession, gender, with a few exceptions here and there. The African indigenous public and commercial law is often not taken seriously. And so how does the legal system, which only a part of the law is important, make it to the center with established, very well versed, written sources are available to everybody. We are taught in law schools, and that is the challenge which is going to be good, hopefully, the rest of the academic career. So we are in perilous times where the reimagination of the African state is more than urgent because of continuing severe and persistent governance crisis, including Africa's peripheral engagement with artificial intelligence, so that we're able to predict the future, that Africa will be at the front of the regulated dominance of artificial intelligence. To give ourselves a fighting chance, we must continue the reconstruction of our moral communities at the local and national level. The inaugural lecture, I suggest, shows the path of how norms of rural African states can be adapted to provide a supportive anchor of this new moral community, which we must reimagine and bring to bear as all of us wait for how the technology of the global north is going to change our lives, make us lose our jobs. Already, the prediction is that in 2 or 3 years' time, 20 to 30% of entry-level jobs will be lost to artificial intelligence. So why that government is wondering how they would manage. We think that as consumers of technology that we will survive. And we really wonder how we think that without paying close attention to how our societies should be constructed, that everything survive what is already happening. Who's, stable on the lock time because it's voted in the service. So his inaugural lecture allows us to think about how we're going to think about this society. How do we survive in a very difficult environment? So every inaugural lecture is simultaneously introspective and perspective. So it's the justification for promotion to full consortium. The many lecturers point us to also their future scholarships. For me, this is the gist of this inaugural lecture. For the Diala is them backing on a huge class. And so I have little doubt that in the kindled public square of legal mitigation will be fierce, messy, and contentious. If you look at the values that is espousing, there is just no doubt that if that debate is brought into being and if there is contention, it will be fierce, it will be messy, it will be contentious. And I think he realizes the fact that these are not the problems, and that as a scholar in this stature, that he knows that these situations will come. But I think that the value of the younger lecture is the fact that he's brought what is been neglected back. All of us who are lawyers in South Africa know that the question of the South African common law just not present in the past decade, if not more. And so the question the legal academia has to answer is, how do they know that this spaghetti bowl of legal pluralism in South Africa can survive without some interpretation and some integration? And so that's what I think it brings to the table. So if the debate which he demands, the local lecture demands that the debate and even more slash. If he continues in South Africa and all other African states, and as I said, South Africa is way ahead of the manner in which this is done. In several of our countries, African states have set into the familiar. And part of that is the production of books, by which we learn the Indigenous law. So everybody who reads law in South Africa University and American University has a corpus of books and precedents from which to debate, teach, understand, change law. And part of the challenge of African Somalia is that it is written, it is oral. Always be recognized. How do you fight the battle with the written system? And that is the challenge. So again, his scholarship in the books is little, is a pointer. And some of us who are in the field bemoan this lack of authority in a sense. Many of us think that the value of African survival lies in its flexibility. It's actually beginning to think that a group of people have laws that can ascertain according to the wishes of elders of the society. Where there is no, we're not talking about predictability. The things which you could do to them to be able to understand what their different relations are. And so that battle with very well established Roman Dutch law in South Africa, very well established civil law in all African countries, and common law. It's a battle between vastly resourced legal powers. And that reality is what I think he understands, and the Center for Legal Education has a challenge for which it produces the books and the articles by which we debate all issues. African indigenous public law is at the core of political philosophy that might be of help in the several African countries that struggle. African commercial, indigenous commercial law has very solid principles that is talked about trust, trading relationship, and then also understand that the banking industry starts with trust until distrust becomes the issue inside the collateral and all this. So again, for the content time, this is not that because it's very important, exceedingly important, not just because of the values it puts out, but because it helps to the core, a key issue that if we are able to follow and have Africa, South Africa debate what becomes our common home, we will be answering the questions of who we are as Africans. We'll be answering the question of what moral communities do we have. As the bulk of our communities are becoming jobless, crime rises, as the promise of the South African post-apartheid South Africa seems to be disappearing as years go by. Across many other African countries, virtually African countries underdeveloped. Actually, somebody says underdeveloped because you can get underdeveloped and you are developing. But many African countries are underdeveloped and are underdeveloped. So, as I said earlier, I decided to keep this short and to respect Prof. Diala's scholarship, to congratulate him on what he's done so far, and to encourage him to bring to bear in the remainder of his academic life his great promise, and to thank UWC for seeing it fit to set up the Center for Legal Integration. In Cape Town here, there are two divides, right? University of Cape Town and UWC. For long, University of Cape Town was the bastion for African customary law and indigenous law. I think that UWC has done the corner a long time ago to him and a couple of other people. We have shown on that what is really important should be protected and balanced. Give ourselves the fighting chance of I said earlier. So thank you for having me. It's really my pleasure to respond to this model. So thank you very much.
Professor Nina, I'm going to ask Professor Diala to do our recognize. She's our Deputy Dean Teaching and Learning and Faculty. Thank you so much for your I'm sure. Good evening, everyone. Good evening, everyone. All protocols observed. It is an honor to have been asked to lead a vote of thanks to Professor Diala for his inaugural lecture on the foundational values of indigenous laws as the framework for African common laws. This is perhaps one of the easiest things I have been asked to do as I conclude my tenure as Deputy Dean in the Faculty of Law. As some of you know, Professor Diala and I are in the same research field of indigenous African customary laws. So since 2018, when Professor Diala joined the faculty,
we have been co-teaching customary law. We have also shared 5 years together as advisors on the South African Law Reform Commission on the review of the Matrimonial Property Act. Through these close working relationships, I've had a unique opportunity to admire how Professor Diala approaches problems on the interactions of received laws and indigenous laws on the African continent, which I'm sure you also got a sense of that approach from his lecture tonight. Professor Diala's novel approach to the interaction of legal orders in Africa presents the core values of indigenous legal systems as a solution for conflict of law problems. While these problems have existed since colonial period, they are significant today under the continent's constitutional dispensations because Africans are in charge of their own affairs. Professor Diala's lecture, therefore, addresses one of the fundamental problems facing our discipline in the era of globalization. Without wasting much of your time, my simple task this evening is to say, Professor Diala, thank you. On behalf of all of us attending here in person, as well as those connected online, we thank you for your lecture and the insights that it has brought to us. And for that, please join me for another big round of applause. And I would also like to call upon Professor Diala to come in front and Ms. Adeli to present a gift. The success of this event is the result of long-term planning and organizing by different stakeholders in the university. In no particular order, I would like to pay tribute and thank the following. First, on behalf of the faculty, the faculty would like to thank the university management for providing the platform for these inaugural lectures. Secondly, the faculty would also like to thank the DVC academic present here, the deputy registrar, the deans, deputy deans from the 7 faculties present here in the different roles that they have played in planning for inaugural lectures and also for being present here today. Your presence and support is greatly appreciated. Thank you, our respondent, Professor Nauchi, in your role to responding to Professor Diala's lecture, and to Professor Miliun, my HOD, as the master of ceremony for tonight. At the faculty level, the organizing and planning of today's event and having such beautifully decorated space was impeccably done by Ms. Davis from the Dean's Office and her team. Please join me in thanking them by also giving them a big round of applause. I am told that we are going to have some refreshments outside, and that has been provided by the nice catering services. So thank you to them also. Last and most importantly, thank you to all the colleagues from the university community and other institutions that are here. The faculty, colleagues from the Faculty of Law, students, visitors, Professor Diala's family, and all connected online. Your presence and engagement have contributed to the success of today's event. And to conclude, and in the words of Professor Diala, he said it already, but I was given the task, so I'll repeat. Professor Diala says, and I quote, "Thank you, my family and my parents. Thank you, Professor Nauchi, for mentoring me since 2007 when I started my LLM in Victoria. Thank you, my in-laws, for giving me a great wife. Thank you all my UWC colleagues and my former HOD, Professor Francois Dutoy, supporting my journey to this stage. And thank you all for coming once again. Thank you.
Thank you very much for being on me. Friends, colleagues, family, I think this brings us to the end of a wonderful late afternoon, evening. I think those are